And we are live. Welcome, Judge. How are we today?
Doing good. How you doing, Abe?
Good, good. And so my name is Abe Mashni. I'm here at the Baldani Law Group here in Lexington, Kentucky. I'm joined by my law partner, Brandi Lewis, and we have a special guest in District Judge John Tackett. How's it going?
Doing fine. Doing fine, Abe.
Good. So here, you're going to have to scoot up a little bit. There you go. So today's topic is COVID and the courts, and as you know, that topic has not only affected the courts, but pretty much affected all walks of life, all businesses, all industries. And so I know that here in Lexington and Fayette District Court, there's been a lot of precautions that have been taken. Mm-hmm. And so, but first, tell our viewers just a little bit about you.
Oh, well, my name is John Tackett. I was born and raised here in Lexington, Kentucky. I'm a proud Dunbar Bulldog, and went away to Chicago for undergrad, then came back here for law school at UK and graduated in '03, and then did a myriad of things. Once upon a time, I clerked for this law firm, but worked for a judge and clerked for Judge Roger Crittenden after taking the bar, and then did some work up in outside of Louisville with a small firm in kind of the northern counties, and practiced. Came back here to Lexington and worked for another criminal defense attorney that did mostly criminal defense, but also a lot of appellate work and a little bit of civil work. Worked for a civil, big and small civil practice, and did a lot of defense work across the state. Practiced in all kinds of counties in eastern Kentucky, and then came over to lift them and started my own practice, and that was a lot of fun. Doing my own thing for about 6 or 7 years, being an independent solo practitioner, and then I ended up running for judge and winning successfully. So, and that's I'm married to a wonderful wife, Sarah, and we just adopted a little girl. She's 16 months old.
Congratulations. That's awesome.
Yeah.
So before we talk about and we got our Mr. Baldani joining us today.
Good morning, Judge.
Good morning.
So can you explain what cases are heard in district court, or what types of cases you preside over?
So we are a court of limited jurisdiction, which means that the Supreme Court decided that we can only do certain things. The circuit court is a court of general jurisdiction. So when they created the district court, they said, here's what you all can do. We can do criminal misdemeanor cases, and we make the probable cause determination on felony cases. We also handle all the juvenile criminal stuff, not the family court stuff, where truancy and all that stuff, and adoptions and family court cases are held in our family court circuit. We also do civil cases with jurisdictional thresholds of $5,000 or less, forcible detainer court, which is your evictions, probate matters. And then I do a specialty mental health diversion court, which is a criminal court, much like a drug court, but the criteria to participate is have a serious mental illness substantiated, and a lot of our folks are duly diagnosed, so not only that they have the mental health issues, but they also have an alcohol or substance abuse issue. But that's an overview, and we do one other thing I forgot is we do health guardianship conservator court too. So if someone has lost their decision-making capacity, whether it be making financial decisions or healthcare decisions for themselves, we make rulings on whether or not they should have a guardian or conservator. And then issuing warrants and those sorts of things. So we kind of do a little bit of everything.
Good deal.
And are all the parts of district court reopened?
Well, good question. So right now, everything is opened for limited in-person with the exception of forcible detainer cases, evictions for non-payment of rent right now. And those are not opened up by the governor and the Supreme Court Justice Minton in the Supreme Court issued basically orders that mirror each other. And so right now, we thought that we would maybe be at a point where we would be taking those in July, but as of right now, those will not be lifted for the state of emergency. There's caveats and there's exceptions that they've issued. For example, one big exception is if it's non-residential property, you can file for eviction. It's a business that is renting. But for folks who are residing there, it's going to be very difficult to meet an exception.
So I know that court is functioning. So you're still calling cases,
right. And we always were. We were even when the state of emergency was declared and we began our initial shutdown, we were always handling folks in jail, whether it be juveniles or criminal folks. We made sure that part was still open. So, and one thing's important for civil cases, we were still taking filings. So, I foresee maybe some statute of limitations issues come up, but, we were always open to take filings and to handle, emergency cases and cases where folks were in jail. But now, yes, some of the restrictions have been lifted such that you can, come to the courthouse now if under certain circumstances.
So there is an option for the most part in a lot of cases, especially in criminal court, where somebody can appear via Zoom or appear in person. What are your thoughts on that?
Well, right now, from what I gather from there's been about 45 emergency orders issued by the Kentucky Supreme Court, and they've mostly modified themselves. So it's mostly like, kind of the same thing, only they made this, tweak or that, modification or amendment. So we've had a lot of reading to do from the Supreme Court. Certainly, their preference is if you can participate by Zoom, if you can participate by video conferencing, please do that for all the reasons that everybody knows, just to reduce contacts with other folks who are brought into a public space, to reduce the judges and the court administrators and the staff from having contact with people, the bailiffs and everybody. We just want to reduce contacts. Of course, the district court, we've got a lot of folks who probably don't have the means to have computers and phones and stuff like that, so we had to make those, in person available when we kind of got back up and running. But certainly the preference from up on high down to us is if you can do Zoom, please do Zoom or video conferencing.
I have a related question. So we do criminal defense, as you know,
Sure.
And maybe more so in circuit court. Like if I have a client coming up for sentencing, I kind of feel like probably they're better off being in person in front of the judge. Although some of my clients might rather be at the safety of my office where they can't get thrown in the holdover.
Right.
But do you think there's any cases or situations in which a person charged with a crime is better off being there in your court versus on your video screen?
Yeah. Well, Russ, we're limited by the technology and what the technology can allow us to do. And there's certain things, as everybody knows who've watched video versus being in person, you lose something there. So especially if it was a probation revocation matter or something like that, it may influence the trier of fact a little bit differently to see the person live, with their family there behind them versus being on a TV screen. All those kind of intangibles. But for the most part, obviously, just as a general overview, it might not make that big a difference, whether they were video conference versus in person. If you look at kind of what the Supreme Court's done with all the wars they've entered. I mean, obviously the motivation is to reduce contacts, so people reduce the spread of COVID-19, and you do that best by appearing by video, so.
Do you have any good stories of attorneys that didn't know how to use their mute button and did something really stupid while on Zoom?
Somebody from your office, his initials are RTR, had a client appear, and she kept on asking if she could be heard in open court, which I was trying to deal with something else, and he was courageous enough to tell her to shut up, during court. But yeah, that's just, that's par for the game. I mean, everybody's getting used to it. I think probably just if I was a practitioner, I know that I've seen, I think some folks from this law office do it, is to have their client with them in the courtroom or in their office,
right,
appearing by video, and that way they can control it better than sending the link out. But yeah, I mean, it's really gonna, I think, change a lot of things. I mean, if you've got a client who you want to enter a plea and they're in California, and they'd rather stay in California, and not come back, and it's not one where you're looking at, incarcerating them, then, why not do it by Zoom? So, I mean, better for the environment, that's for sure.
I'd say that if you have a pending warrant, it would be frowned upon to appear via Zoom.
Yeah, that would probably be true.
Although I had one in circuit a week ago, and I was going to do it in Zoom, but they had a PFO warrant, and the judge's secretary said you can't do Zoom because there is a warrant. So you can't skirt around getting arrested by appearing on video.
No, and that's something that I guess we're probably going to need to do a little bit better job on, from my perspective, because a lot of times I don't hear about the warrant until the case is called and the person is presented. So, and if you were to have a heads up and be notified, then you can contact, if they're represented by counsel, and say, look, we need them here, we need to have this warrant served on them. So,
yeah, another issue I thought about, I think it might even been your court last week, I'm not positive, but an attorney was doing a court appearance in court, but his client was in the jail. And he was trying to decide whether to have a preliminary hearing or waive the case to the grand jury. And the decision kind of based on whether you reduced the bond. And so once the bond decision was made, the attorney had to talk to the client at the jail about whether to waive a preliminary hearing. So it does get a little, Zoom has a lot of advantages, but I thought it was kind of awkward to have to, and it wasn't any way around it, but you had to talk to your client in front of the whole courtroom about what do you want to do. And that would never be done in open court.
Now, once we get beyond COVID, certainly Zoom is going to, if we continue to use it, which I'm totally in favor of doing, we wouldn't have those issues. But right now, I think probably the biggest headache is that the jail is being extremely protective for good reason, because you saw what happened out at the federal prison, so the jail is basically really on lockdown. So the only way that, especially if you look at the public defenders who have multiple clients out at the jail, it's about their ability to talk to them. And unfortunately, I'm not pointing the finger at anybody, but just even with their best efforts, they're not getting to communicate with the folks that they represent like they would typically be able to do by just going to the jail. So you're right. It's been one of the most awkward and difficult things, is that we're really having conversations with criminal defendants in the jail, that in open court on the record, that normally would be, private conversations between public defenders and their clients. But we're trying to, articulate exactly what's going on so people, make informed decisions about what they say, during those conversations. And, you're being recorded, this is, and folks have, anything you could say, you have the Fifth Amendment, right? All those things are being talked about before you had that conversation, but it's awkward. It truly is. So, and I don't think that's going away until the virus goes away, unfortunately, just due to the circumstance we're dealing with.
So, Judge, one of the, I think the biggest things, at least in the criminal defense world side of things, is almost the experimental bond reform that this virus has caused. Coming from all levels of government, you've got, and especially Chief Justice Minton, who's been widely outspoken about trying to get people out of jail because jails and nursing homes, it's very hard to be socially distant, and as you noted in the federal correctional jails and prisons, that has been a huge issue. And so what is your thoughts about what has happened? I know that there was a study that came out that Justice Minton mentioned a few weeks back about how there's been some prison populations or county jail populations that have decreased by over a third, and yet we have the same percentage from 2019 to 2020 of reoffenders or people that are committing crimes while on pretrial release. Do you have any thoughts on that?
Yeah, well, you mentioned the study, and what it is what's happened is the Supreme Court has issued orders expanding what is called administrative release, or what I think of it as automatic release. Is if you meet these criteria, the judge doesn't make a decision on bond. Pretrial release officer will just automatically release you without any sort of discretion being exercised whatsoever. And so that's been expanded a lot due to the virus. So, I guess my opinion on it is kind of wait and see. I would say, as to what the data will end up showing in the future, whether, we have a lot of folks that go back out and reoffend while they're on release, or, fail to appear. Because that's really, that's all you're making a decision on when you set a bond is this a person that is potentially dangerous to our community, that's going to commit a crime while one is pending, or, is this person a flight risk? Can I rely upon this person to come back to court? Those are the two considerations. And we get, a pretrial report that basically weighs the data and says, he's a high risk of, coming to court, or he's a, moderate risk of potentially reoffending, especially, and that's the concern, especially if it's a violent offense. You don't want someone to, that's been caught to go back out and do something violent, and so that's certainly our concerns. So, long story short is, I guess we'll just have to wait and see. The one thing I would say is, you're taking discretion away from when you do a blanket rule and says if anybody meets these criteria, they get out of jail no matter what. So you take discretion away from people who have been elected, to make important decisions on whether or not we want to keep someone who is allegedly, it's just allegations by the time we see them in arraignment and whatnot, allegedly committed these offenses, to stay, in jail where we can guarantee that they won't commit another offense, and we can guarantee that they will show up to court. And so there's some cases that, I'll just say, we had a lot of angry people with the DUI accident that happened down on East Main Street with the motorcyclist that was killed. And that person was released by administrative release because at the time it was just a kind of a DUI whereby there was serious, it was a serious crash, and there was serious injuries, critical injuries that ended up being fatal, but they couldn't charge him with anything other than DUI at that time. So none of the judges made a decision. That person was automatically released, and a lot of people were very, very, very upset, and rightfully so, because that wasn't really, if you had a judge and you said, by the way, judge, this person hit somebody and they're presumed to possibly, they may not make it, they probably wouldn't release that person. I can't think of a judge in the state that would release that person on their own recognizance, which was what happened. And then later, that person died, and they issued a warrant and set a bond of $75,000, and that was probably more in line. But it also happened with the kid that got the child that was killed over at UK during the football game. That person was released automatically. So I'm just saying, there's exceptions that would probably you'd probably prefer a judge to make a determination as to bond that that you're not going to get when you just have a blanket rule. So, but we'll see.
And unfortunately, these highly publicized cases gets the public in a frenzy, and they don't really know.
Yeah, well, and why would you know the mechanisms by who gets automatically released, unless you're a really student of wanting to read 45 really long Supreme Court opinions, so, or orders.
Right. Well, do you have any advice? I know you touched on a little bit, but advice for attorneys that appear before you on Zoom going forward?
Just, the mute button is your friend, I think. I've had to mute one attorney, but his initials are DG. I don't know if anybody would know him, but I mute him quite often because he doesn't realize he's talking to his secretary very loudly, disrupting court, so just make sure that pay attention to that mute button. Again, we really, I think we figured it out. Thankfully, I mean, it's technology, and it'll fail. It's just, it's bound to fail at some point. But we've had really good success in getting things accomplished by Zoom so far without major headaches, even though we encounter them, here and there. And really, if this is about, making sure everyone's safe and reducing the spread of COVID, then, just don't be afraid of it. Take advantage of it if you can, and you understand you got the computer and the ability to do it. So
I will just add, I am on time for 8:30 court now, thanks to Zoom. I appreciate that.
Yeah. Oh, yeah. I should also say, please, wear a tie. I don't care if you're wearing shorts underneath, but put on a tie at least. I've had some attorneys show up in their golf shirts and T-shirts, and it's
Do you tell them to wear a tie?
It's disrespectful. Yeah, I do.
Yeah.
They're not in the courtroom where I could really, get after them, but just, show respect to the court and at least put a collared shirt and tie on. And
so jury trials are supposed to resume August 1st.
Correct.
As of today. That could all change.
Right.
How do you foresee that looking, and how are you going to socially distance the parties and the jury?
Yeah, so that's, we're in the middle of conversations right now, me and my colleagues, as to what's going to happen. By the orders that we've been handed down, we can only put 33% of normal capacity in the courtroom. Then you've got the added, worry that, for the folks that are called for jury duty, I just envision who shows up, and a lot of those folks are who I would put in the at-risk category of being over 60 or 65, and they may even, I can't tell by looking at them, but, certainly people younger than me have underlying health conditions that would, prevent them. So it's going to be truly hard, even though, we all know that a defendant has a right to a speedy and fair trial, to compel folks to come to court as jurors to sit, during when we don't have a vaccine and COVID's still out there. So, the best we can do, of course, you have to have a face covering on. We're disinfecting the courtrooms after every court proceeding. We've got exits to space people out so they're above 6 feet apart, at all times. But I can see it. We have, like I said, we're really starting to have conversations about it, so I can't commit to anything, and our chief hasn't issued an order on it, but, voir dire may take longer because, and voir dire is for jury selection, as we all know, the attorneys here, But when we pick a jury, you might have to ask the same questions to 3 separate groups of people that come in, you know, and tell others to, you know, we'll see you back at so everything it seems like is going to take longer than it typically would otherwise, and I think we all have to just get accustomed and used to it.
So you probably know I started a federal trial
I heard
February
about that.
24th.
Yeah, and it went through.
Yeah, so on February 24th, COVID was just something in China and overseas, and it wasn't a concern of anybody, but 2 weeks later, it became a big concern, and it turned out we were the only federal trial in the country to go.
Yeah.
And I would have bet every dollar I had that the trial would never have completed, because I thought the jury would just not feel safe, comfortable.
Sure.
But it was actually the opposite. They were so committed to the process, and I don't know, there was a little speculation that Judge Caldwell made them feel so comfortable and was so concerned that they were glad to get out of the house and come to a safe place.
Right.
But I mean, it went straight through, and the jury deliberated 8.5 days before acquitting my client.
Right.
But
And
it was an amazing experience. At one point, the judge sent back to the jury room masks and gloves and other PPE, and the jury sent out a note saying, want to know, could they donate it to the first responders? So,
wow.
I mean, it was an all-star jury. It was amazing.
That's great.
Yeah.
Yeah, but I mean, you hit on exactly what we want people to feel is, you know, because no one shows up at the courthouse. Maybe me. I show up excited to be there because I don't like being there. But for the most part, people don't. You know, the courthouse is not exactly where they want to spend their time. You know, and especially if they're being compelled by the government to appear, we want them to feel as safe and comfortable as possible. You know, so we're gonna have to think about ways to do that. And of course, you know, with everything I've said that we're doing with the face masks and the disinfectant and the hand sanitizer all being available and spacing people out and following CDC guidelines as best we can, hopefully they will feel like, you know, they were never endangered by coming to our courthouse. So.
Let me ask you this. It seems to me that proudly Kentucky has really been a way ahead of many other surrounding states and other states. The governor, and our numbers reflect that. Do you see the way the court system has handled the situation? I mean, do you follow what goes on in other states? Do you think we're doing a better job like I think we have in general? Do you think the court system is doing the same?
I hope we are. I mean, honestly, I'm lucky to know what's going on, like in the Fayette County District Court, you know, so I don't pay attention a whole lot to what happens in foreign jurisdictions. But, you know, I mean, I feel like our Supreme Court has really, you know, been extremely proactive, you know, from the beginning, and they've been really on the same page as the executive branch, and they've been, you know, pretty much on top of it. That's what I would say, and they've given us clear instructions from the get-go, you know. I mean, and things turn, you know, like we were having, you know, probably a crisis every 30 minutes as to how we're going to do this, how we're going to do that, you know, back in March when we first were entering the shutdown. But, you know, we survived, and we got, you know, some pretty good guidance. And I'm thankful that the Supreme Court chose to be as, you know, proactive as they did for us that are way down the food chain. So,
Judge, last question. We'll get you out of here soon. But the biggest issue as far as trials as I see it, other than the just efficiency, it's probably going to take longer, and there's going to have to be a lot of precautions put into place to keep people safe. But is judging the credibility of witnesses if the witness is required to wear a mask.
Yeah.
And so obviously, I mean, people have facial expressions when they testify, and I find that would be difficult for a juror to do.
I think that's a great question. I mean, because you know, I want to say that somewhere in my education, I learned that 90% of all communication is nonverbal, and so certainly during the trial, the jurors would want to, really truly examine the witness, whether it be facial expressions or how they respond nonverbally to questions, and I appreciate that, and I think that if you didn't have that, that would be a good appealable issue, if you were to lose. But I guess this is what I would say. I think that even with the components of a courthouse and how big a courtroom usually is, that we could probably find a way to have the witnesses testify in a safe environment where they're 6 to 10 feet away from the nearest person, without a face covering. Frankly, I thought that would be a good question as to during voir dire, because you probably want to see your prospective jurors like faces and their expressions too.
Absolutely.
So I mean, it would go that way too, so it's something that we certainly would have to take up, but I think that it would probably be something that we'd want our witnesses to be in a place, which we could probably accommodate, because you see these folks that come up to the microphone and talk like we are now. We're further than 6 feet away from each other, and there's less chance of us passing the disease, and we're not wearing face coverings. So that'd probably be what I would suspect would happen with a witness.
So what if my client had a mask that said "not guilty"? Would you let him wear that?
You have a tie that says that, right?
Yeah.
No, I think we'd probably have to limit that might be a breach of the Fifth Amendment there. You'd probably have to put your witness on the stand. So after that.
Okay, just checking.
Yeah, I don't think that would fly.
Well, Judge, I really appreciate you coming down here, talking to us.
It's nice to have this way to, if anybody's curious as to what's going on, try to educate the public as to how we're making changes and trying to keep people as safe as we can. So.
Thanks, Judge.
You're welcome.
Thank you so
Appreciate
much.
it.